Okay, guys. Well, I'm going to go ahead and get started here. I'm glad to see a few people showed up. I was afraid it would just be us for a few minutes, but we have some people here today, and that's always good to see. Probably a few new people and a few old people. Not to say that you're old, but we've been together for a while. Uh, Today, we're going to be talking about drafting contract provisions and how we can do that a little bit. Drafting a contract is a little bit different than any other kind of writing that we do because we have to be so precise about things. It's even more important in contracts. We have to look into the future, which is sometimes easier said than done. This is the first time that we've done this class, so I want to get through this material as best I can. I'm afraid I might have packed a little too much in, but as you know, that probably will just mean our exercises at the end will be cut short. Don't worry, I have other exercises, some even in the beginning, so stay tuned. My name is Jeff Kaiser. I've been a practicing attorney in the US for 15 years now. I've also been teaching English to people like yourselves, lawyers like you, for years. And so one of the things I've done in my career is to start working with foreign lawyers and try to help them maybe rewrite a document or edit a document. And it's been such a great experience to really see how people from different places think, how they work, how their law brains function. I've traveled everywhere. Right now, I'm coming to you live from the beach in Da Nang, Vietnam. It is about 30 degrees today and quite sunny out there. Um, I'm sorry to rub it in anyone's faces where it's cold, but it's a great day where I am, and I absolutely hope it's a great day wherever you are. If you haven't already, please send me your name, your email address, and the law firm that you work for in the chat window. It lets us keep track of who's here and who's liking our classes and who's not liking our classes, and maybe we can reach out and try to get some more information about what kind of classes you might want in the future. Um, Another point I need to make is about our website, legalwriting.eu. It's a fantastic website filled with all sorts of great content about our classes, us as people. There's a section on the courses that we offer, and you can even leave reviews for me. But beyond that, it's just a really great resource for any lawyer that needs to start writing or communicating in English. Uh, Last thing I'll mention before we start getting into the fun stuff is our virtual learning environment. I've been told that you all have credentials for this now, and that you're able to get in and play. There's quizzes, there's copies of our videos, and I believe our PowerPoints are all there. Other stuff too. So go check it out. If you want to show off how smart you are, you can take the quizzes and get badges and get all sorts of cool stuff. So I hope you come check that out. All right, now let's see here. Let me share the right screen again. There we go. Letting people in. There we go. All right, our upcoming schedule of classes. Next week, we have the Advocacy Toolkit, which I'll need to start working on just about as soon as we're done here. And then we're going to learn about how to ask the right questions. And then we have a couple of repeats. So I hope to see you all there. If you have any questions about any of those, please do reach out to me or Josh. We'll be happy to answer any questions or help out in any way we can. Okay. Any of you that have had one of my classes know that I tend to start with a quote of the day, and today's no different. This one comes from Samuel Goldwyn. And if you know of the movie studio MGM, he's the G in MGM. So he's an old-time Hollywood movie producer. And I thought this was just a great phrase because it's more or less true. Verbal contracts are difficult. All right, through the preliminaries, now we can get to the fun stuff. And that's going to include a little quiz. And I absolutely hope that some of you will jump in the chat window and try to answer these. You can also jump on if you want to feel like speaking, knock yourself out. But it would be great if I could get some some participation from you. These aren't too tough. And I'll start with one that I almost kind of already told you the answer to. Can a valid contract be concluded by means of spoken words? Yes, thank you, everyone. Yes, the answer is yes. The problem with and then my caveat there is for the most part, there are certain types of contracts that must be in writing. Generally, leases have to be written. There are the statute of frauds that say generally a sale of goods over $500 has to be in writing. Those may differ wherever you are, but I just want you to think about there are some contracts that cannot be affected orally. All right, in a contract, what does the word void mean? Yeah, very good. It's yes, it's that I will give you a full definition in the chat window. It basically means that it has no legal effect, that it's an absolute nullity, like it never existed in the first place. All right. I'm gonna do one more of these now, and we may come back to them at the end if we have some extra time. Let's see how you do here. This one's a little bit more difficult, but we'll talk about this later too. What name is given to types of clauses in contracts routinely inserted into commercial contracts, excuse me, that deal with the way the contract is governed? Because I told you this one's a little bit harder. Yeah, look at that. You guys are very good. That's right, a boilerplate clause. They're not the most exciting things in the world, but I think just about every contract I've seen has them. All right, well, I'm going to skip the rest of these for now. We may come back if we find ourselves with a bunch of extra time. I have other quizzes at the end, but there's a lot of material I want to get through first. And we'll start with something that we don't really think about that much. And this is what the structure of a contract is. In my practice, and I've written a lot of contracts for a lot of different people in a lot of different situations, I've never really thought about the structure. I've thought about what people have done in the past, and I certainly stole some language from other contracts. And yes, I've all told you that working from templates can be very dangerous in legal writing. I'll take some of that back when we're talking about contracts, because a lot of this needs to be repeatable, and cutting and pasting is a great way to cover our bases just in case something goes wrong. So before we get into how to do that, we should think about what actually makes up a standard commercial contract. A lot of this is fairly common sense, of course. The definition section is a section of definitions, but there are still some things to discuss there. A preamble, it's where we all start. And this really just is much like a caption to a case or the heading of an email or a memo. I think we've all seen, and if you've worked with contracts of any kind, you've seen this kind of sentence lead off the text. And please correct me if you think I'm wrong, but this is a sentence that I don't think any normal human would write. But lawyers like to include this in all kinds of contracts. As a matter of fact, I wrote a contract for a client this morning, and I led off with something very similar to this, a little bit more fleshed out, but if I hope this is all making sense to you guys. I really do. Stop me if it doesn't. I forgot to give you my standard warning. Preamble, though, it's pretty easy. It's basically who's involved and what we're doing there. The recitals or an introduction. This is basically just that. It gives an introduction to the contract. Maybe give some motivations for why we're entering it. It might identify some important terms and some third-party clauses, third parties that may be involved. But it's very important to remember that these may not be considered part of the substantive agreement. They may not be enforceable on their own. So in a lot of ways, you can think of this as just a quick summary of what you're going to do later on. Here's a quick example of what a recitals or introduction looks like. Has anyone seen this kind of language in contracts? Yeah. And I'll stop right here. I obviously didn't write this one. I've cut and pasted this from existing contracts. And there's a few elements of legalese that just bother me here. Witnesseth whereas. And you use whereas 3 times in this paragraph. Is it a paragraph or a sentence? I think it might just be a sentence. My goodness, we are humans. We are not 18th century lawyers. So even though you see this kind of legal jargon and this kind of legalese in contracts, especially introductory paragraphs, especially where we want to make it sound like it's a really big, important, fancy document, you'll see this. And it's okay sometimes to a degree. This one just, it feels ridiculous to me. We could probably cut a lot of that out and still be perfectly effective. Definition section. This is such a great thing for any kind of long document, not just a contract, but any kind of a long memo or a long brief or anything where you're writing, oh, I don't know, maybe 10 pages is a good place to start. It shortens your document, and it allows you to frame and really define any terms that might be ambiguous in some way or another. For example, what is a vehicle? I think if I asked all 47 of you individually, we could probably argue about what a vehicle is. But if we define it in our defined terms or definitions section, then the argument is over. Then at least we know what a vehicle means in this contract, at least. This is a skill, and this is all of the times that I've talked about how our goal is to write short, clear sentences. Nowhere else do you see that more exposed than when we're writing definitions. It's great. It's a great tool to work on, and if you can write a good definition, you'll be able to not just explain what's happening, but you'll be able to argue it. And that's where what you want to be as a lawyer. At least I hope so. One tip I always do is to define them as you're writing your document. We like to sometimes just cut and paste a definition from the OED or some dictionary or Black's Law Dictionary or something, some source. But what we really can do here is create our own definitions. If we want those words to operate using someone else's definition, we don't really need to define them. But do this as you're going through. At least bold those terms that you might want to define and start thinking about how your definition could help win or lose or get more out of a contract that, or basically it might help you in negotiations. Conditions precedent. These are basically triggers that allow the creation of the contract. I make a reservation for a convertible rent-a-car, but I tell them I only want it if it's a nice day. Then there would be no contract on a rainy day. So in order for my contract to work, it would have to be a sunny day, just like today. So these are the things that need to happen to allow the parties to have an agreement. For example, if you agree to deliver bottles of water, but only on the condition that you know where they are to start with. If they're not delivered there, you're not able to deliver. So the condition precedent failed. We can also talk about the impracticality or impossibility of the terms, but that's more about performance of the contract. Okay, we're getting through this. The body of our contract. This is basically what we're agreeing to and why we're agreeing to it. Sometimes the why isn't even that important. So the terms of the agreement, what consideration is being exchanged here? What are the parties' duties, responsibilities, obligations? How is the contract performed? All of that comes in this section called the body. Now, I think I've mentioned this in another class, but I will mention it here briefly again. What it takes to form a contract is very different in a common law system from a civil law system. I won't go into all of those requirements here because we don't have the time for that. I'd love to talk about it, believe me. But in the common law system, generally, we need to have an offer, an acceptance, consideration, capacity, meaning that the parties are over 18, they're adults and able to enter into a contract, and legality, meaning that a contract for illegal drugs would be found to be null and void because you can't contract for illegal goods. If you come from a civil law tradition, your formation elements may be different. In fact, they probably are different. And there's a lot of little quirks in my simple description. So we won't spend a lot of time there. We won't spend any more time on that. But this is where you want to talk about that. How you arrived at this agreement, what's going to be exchanged, how it's going to be exchanged. This is what we think of when we see a contract, right? Like this kind of things. I'll give you just a second to take a look. So I think we've all seen contracts like this before. At least I think if you've worked in the law much at all, you've probably seen contracts that look like this. Or I mean, I should say like this because you usually end up being this thick with 1,000 pages of other stuff. But this is where we want to elaborate on the exchange. We want to talk about what goods and services are being exchanged in the clearest and most easily understood language with as much detail as we can. We have an agreement, right? If we're writing the contract, we have an agreement on the table. We want to maintain the good faith and try to make sure that our document represents that agreement. So we have to state the agreement. I know this sounds so obvious, but what is one side promising the other side? This is where all of my talks about using short and simple sentences with clear, short language. Listen, this is where it's really important to follow through on this. As you know, courts usually rule on the interpretation of a contract against the person that wrote it. And when they do, they judge it based on a reasonable person or an average person, not a lawyer. We don't want to just be able to defend our contract. We don't want to be able to go in and say, yeah, but if you listen to the clear meaning of the words, this is what I intended. We never want to do that. We want the words to speak for us. And that's just through practice and exercising on how to write contracts. So detail is great. We can't assume that people will do anything that is expected that falls outside of the contract. We can hope, I guess, sometimes, but if it's not in there, if it's not written down, there simply won't be any guarantee. So I'm going to go through a quick example here about what a bad explanation about the details of the exchange looks like. And then maybe we'll see a little bit later a slightly better one. Alex agrees to write an article for Ben's website. Okay, before I go on, can anyone tell me what's the problem here? Nobody? No guesses? Okay, it's a tough room today. Must be busy over there. Okay, but I appreciate that you're here. That one was a problem because it didn't clearly explain what either party had to do, at least not in enough detail to make it enforceable. So on Alex's side, there was no discussion about compensation or where the ad will be run. And on the other side, for Ben, there's no idea about how long the article will be done or will be written or when it will be done. So just there, it's a problem. Here, look, this one is a little bit better, I would say. So that way, both sides know exactly what they're getting. So if you're talking about the sale of goods or exchange of goods, describe the goods as thoroughly as you can. Instead of saying Alex is going to sell his car to Ben, say that Alex will sell his 2020, let's see, Ferrari Testarossa, red one, on this date for this amount of money. That's the best way to get where we want to go. Now, Here's a resource that I have used a great deal when I am looking for how to write specific clauses. There's a searchable database of contract clauses. So if you want to have an arbitration clause, search arbitration clause in there and you will have thousands of examples. Now, I'm not ever going to say just a straight cut and paste is the way to go, because that can cause problems. But if you have a template like this, it becomes much easier to craft it for your own use. One moment, and I will even show you what it looks like. Let's see here, let me change my screen. So let's just say we're looking for arbitration. And you can put whatever kind of clause you're looking for. And boom, thousands upon thousands of sample arbitration clauses. This is a great tool for contract writing, people. And I hope that you take advantage of it, because it's amazing. I don't know if you've looked at this before, but it's a great thing. Sorry, I went too far. Everybody doing it okay out there? You can hear me? It's awful quiet on your end. Okay. So here are a few things that are found in most contracts, and they're especially ripe to use a template on. These are ready-made, all-purpose clauses that just end up in most kinds of contracts. Things like a force majeure clause, for example, or the choice of law, or an arbitration clause. These are examples of, there are probably thousands of different kinds of boilerplate clauses in contracts. Use these. They do end up protecting your rights, and can help your contract be a little bit tighter when it's done. My only warning, as with anything template or form based, is to just be very careful. If we miss, cutting and pasting a party's name and the wrong party appears there, or if we don't change our facts to fit our situation, it can be a problem. Here's just a quick example of a couple different boilerplate clauses. I think you're probably pretty familiar with this kind of thing. I may use some of this in my legal jargon class, because some of these are just overly complex for no good reason. And we could talk about that ad nauseum, but that's what we should do. We're getting towards the end of our structure, and then we'll have some fun-filled tips and get into some more fun stuff. Let's see here. Yeah, not too far at all. The schedules. If your contract has a list of 10,000 items you're buying, we shouldn't include that into our the main body of our contract. It's a lot better to separate that and attach it at the end of a contract. It can just become clunky and make it very difficult to understand. All of this is for simplicity's sake only, no other reason. When we have long, complicated schedules or spreadsheets or lists, it's important. It's obviously a very, very important part of the contract, but it makes it difficult to point to where our obligations lie. So we put that towards the end in the schedules. Note that here, these kind of things are part of the substantive agreement between the parties, and so they are enforceable. The signature sections, I think we've all seen enough about signature sections. We know what's going on there. But it is important. It's important to make sure that the right people are signing, and to make sure if they are signing in a personal capacity or as a CEO of a corporation. All of these things are important to consider, and you shouldn't ignore it. Basically, everything's printed out and people sign the bottom, and voila, you have a contract. Appendixes at the end, these are more reference material. It's not necessarily part of the agreement between the parties. It's just more explanation kinds of things. For example, if you have a contract for the sale of machine parts by one company to another, the appendixes to the contract might contain drawings or spec sheets or other things like that, just to illustrate what we're talking about. Okay, that's it. That's the structure of a contract. So how do we manage this? If besides just cutting and pasting things all the time, which is, I know, a temptation we all struggle with, there are some things in contracts that a lot of people forget about, or things that we may want to add to have a more complete contract. One of those is a confidentiality clause, or an NDA. Again, like I said, I just wrote a contract for a client this morning, and in it I included an NDA because he didn't want this getting out. I probably shouldn't have said anything, should I? I guess if I'd mentioned a name or a product, that would change it, but I didn't. And this is a fairly common clause. Sometimes people let it slide, and I think it's always a very good idea. Similarly, a non-competition or non-solicitation clause is a good idea. And yes, in my contract this morning, I also included these because it was for a sale of a business to another person. And part of the deal is, if you buy someone's business, is you don't want them opening basically the same business with a different name right next door. These are good to include in contracts. Again, it's more of an umbrella of protection for your clients if this is there. Another thing that deserves some discussion is how a contract ends. Sometimes there's just a term. I will lease you this apartment for 1 year. Of course, there are rules about how that automatically renews after that year. But generally, we can say that a contract lasts this long, however long you want it to be. We can also have it end upon a condition. If they open the borders in my country, I will go home. But it's almost like another condition precedent. We can also terminate for cause. If someone breaches the contract, then it's another way that our contract could be breached and terminated. It's also a good idea to talk about ADR, alternative dispute resolution terms, if you want to arbitrate or mediate, whichever one you like. Choice of law rules. All of these things relate to what happens after the contract ends, and we should always pay extra attention to this because it gives us a chance to help decide the procedure that we want our contract to rule under. Like I said earlier, when we're writing a contract, one of the first things we should probably check is the legality of it. Like I said, you can't have a contract for an illegal purpose. A contract for murder is, or hiring a hitman is illegal, and that contract doesn't exist. It's simply null and void. Now, in the commercial world, we don't get quite so much of the hitman kind of cases. But we do need to make sure that our parties are the right parties. We need to make sure that we are using the right name of the corporation. We need to make sure that everything we're talking about in this contract is legal. This sounds like it's going to be a very challenging thing to do. It really isn't. Because when you have a contract, you just need to step back and look at what the obligations and duties are for both sides. If it's a sale of goods, that's not illegal. If it's a sale of heroin, that's illegal. So this is something to do not just at the beginning of when you start drafting a contract, but do it at the end too. If you screw up this one, it just makes you look pretty unprofessional and pretty dumb. And it's such an easy thing to confirm. So take a few minutes and make sure that you do. I truly recommend it. Keeping it simple. Is everyone sick of me telling them to keep it simple? There's no requirement for a contract to be a fancy legal document. Like we said earlier, a contract can be an oral agreement. It doesn't need to include all these whereas and in witnesseth of. Parties like this sometimes, and I understand that pressure to give your client something that looks impressive. If they like that, then go for it. Use all of the big words you like. I'll admit it, I did that this morning in the contract I wrote, largely because my client will like it. That being said, I want you to think about the actual purpose of your contract, of your writing. Sometimes it is to keep your client happy. And then if that's your main purpose, do it, whatever it takes. But other times we want to simply express an agreement between parties. I will buy your 2020 blue Toyota Camry for $20,000. If you can deliver it to my house today. There's no need for the in witnesses ofs and whatnot. It's just not necessary. So even though it's a part of contract writing, it's impossible to avoid. I want you to start thinking about it as not being completely necessary. The more simple and the more short we keep our sentences, the easier the duties and obligations of the parties are to understand. To me, that's our ultimate goal. Identifying each party correctly. This is clearly something that, oh, excuse me, I clicked the wrong thing. This is a challenge sometimes, especially when we have a client with 70 different corporations that all have a relatively similar name. I don't know if any of you have dealt with those clients. I can tell you I certainly have. I won't say the names, but he had approximately 50 different corporations, all designed to handle one part of the construction of an apartment building. So there was an accounting corporation, and there was a site management corporation, and on and on and on. But they were all called essentially the same thing with a slight difference. If we mess this up, we may have the wrong parties signing to a contract, which is, it's not good, let's be honest. This is something that we have to be careful with. And I am aware that most big law firms now have these database programs that basically tell you the parties themselves in perfect detail. But this is something that is absolutely worth a last minute check before you turn this in for execution. Agree on how to resolve disputes in advance, even if that means discussing liquidated damages in case of a breach of contract. You won't be able to agree to this with every negotiation, but it's a great way to know what the parties' options are in the event of a breach. The most common thing we'll see is an arbitration clause or a mediation clause or both. There's a part of me, my legal scholar side, I don't like arbitration so much because it seems to take away the legitimacy of the judicial system. I like the courts, I like the judges, I like the whole ancient procedure. I like that, and so arbitration is removing that from our world, and it makes me a little sad. That being said, arbitration or mediation is faster, it's cheaper, it leaves everybody happier, and it's really hard to argue against. So my love of courts is such an emotional response. The best thing we can do is to agree beforehand on how we resolve any kind of dispute that might arise. An indemnification clause, I think most lawyers know this. This happens sometimes, and it's a good clause. Again, Law Insider / clauses, you could see samples galore of indemnification. In some contracts, we need to talk about limiting the scope of that contract. Maybe it's a distribution agreement for a product, but we need to limit it to a region. Sometimes that can be a large region like the EU or Africa, but generally it will be a smaller geography to deal with. Again, these are not for every kind of contract out there. These are for some contracts. When you have something that has a limited scope, you should note that in the text of the agreement. Okay, who here has seen this kind of clause in a contract? Ah, I get some thumbs up. I like that. Yeah, this is super common, and you know, to me, it doesn't feel like it says all that much. It seems like it's it should go without saying. I have a quick history lesson, a legal history lesson for you. I promise it's only 2 slides. I'll make it as quick and painless as I can. That kind of clause comes from English law, which through the parole evidence rule means that you can't have oral testimony explain the contents of a contract. However, if you could show that the contract was not intended to capture the entire agreement, then you can discuss outside evidence. They use that clause, that entire agreement clause, to exclude that exception. And it allows everybody involved the certainty that this agreement that they have in their hands is the agreement entirely, that there's no need to discuss any ambiguities. It's standard boilerplate stuff. People have seen this before. It looks boring, but there is a historical reason for its existence. And at least in the common law system, that's worth knowing. A force majeure clause. These are something that everyone knows about and has been, it in 2020 has become a big deal. Is COVID an act of God worthy of canceling contracts? I think sometimes yes, sometimes no. Um, it's real tricky to say when when an act of God exists, and I think that there's always going to be uh, room for argument there. Uh, but this is a strong clause that it can be very difficult to get around. Um, it's if it's there and you experience a volcano explosion. I heard that somewhere in Iceland there's another volcano explosion. Uh, it's hard to argue that the other side of the contract needs to do it. It would become cost prohibitive and lose any efficiency that it had in the past. Okay, and our last topic before we get into a fun-filled exercise for you guys is about liquidated damages. These are basically contractually agreed to damages. So if there's a breach of contract, we can discuss beforehand and say that my damages in a breach of contract situation will probably be $1 million. And if you can get the parties to agree to this, then you can get away with an entire damage section of a trial. You can't go crazy with this, though. If the courts find it unreasonable or punitive, it will probably not be enforced. So you can't go crazy and try to get that $1 billion off of Zuckerberg that way. We'll try other ways maybe. Okay, so like I promised, and I always deliver, it's time for a quiz, and this is going to have, I'm not exactly sure here, but probably about 5 questions, and then I will be happy to let you go. So what we're doing here is looking at the problems in this text. There are 3 or 4 edits here, and I'll give you a minute or 2 to see what you can find. All right, I'll help you with this one. Just so you see where I'm going with this, and then I'll let you do the next one, okay? I hope somebody will jump up. So here, there were 3 errors. Instead of what, we want to use which or that, depending on what the obligation is. And here eat isn't even a word. We could say herein. And in accordance with is the prepositional phrase that we needed to catch. So this is pretty tricky stuff. I hope you guys are ready. I'll give you a couple more minutes. Aha, somebody got one. I see one, and it is the parties to the contract, or this contract, I think might be okay. All right, I know our time is getting short. We've only got a few minutes left, so I will walk you through this. The other one is we were missing cannot should have been one word in this context. That one was pretty tricky. And the written consent of all parties here too. And I know, that was a little tricky, I admit. Try this one real quick. One of these is pretty easy. Two of these are pretty easy. Actually, all three of these are pretty easy if I have to say so. Yeah, that's one. Okay. Yeah, it's funny, I didn't even catch this one on the first look. That this agreed, that it should be agreement. I didn't even catch that one. Because it's a real word. Microsoft Word probably wouldn't have caught that one. But yes, invalid is the word. Unlawful is the word. In our view, not our view. How it first appears is probably a better phrase than how it looks on first appearance. Appearance is also misspelled, so it's kind of a double problem there. All right, we'll do one more of these and then I will let you go. I won't even go back to those quiz questions at the beginning because you all seem so sleepy. Here we go. Of course, the purchasers have, it's a possessive, has to have the apostrophe. When we have numbers over 10, we generally want to write the numerals instead of the words. The one thing we never want to do is to write both of them. So many lawyers like this trick, and there's no reason for it, where they write 28 in words and then in apostrophes write the number 28, or vice versa. That never needs to happen. And similarly with the 3.5 million, with round numbers like that, you want to write it out as 3.5. If it was 3,547,192, then you would write out the full number. Okay, guys, that's all I've got for you this week. I hope one day you'll come in with some great participation energy. As always, I'll stick around and answer some questions if you have any. But we got through everything, and that's a good sign. Next week was an advocacy toolkit, which I need to start working on soon. But it will be a new class, so that's exciting. I hope to see you all there. In the meantime, have a fantastic week, and we'll same time next week. Have a good day. Bye-bye, everyone.